Good afternoon. Thanks for joining Family Caregiver Alliance for Estate Planning 101 for California property owners. I'm Calvin Hu, Education Coordinator at FCA and your host. For 4 decades, FCA has been working across the Bay Area and the nation to improve the well-being of family caregivers. We offer support through consultations, classes, workshops, publications, retreats, research, and advocacy. If you'd like to learn more about us or access our online resource center, FCA Care Journey, please visit caregiver.org. Now for some quick housekeeping. During the webinar, your phones or mics are going to be muted, so if you have any questions, you can ask them by using the Q&A question box on your screen. We'll answer as many questions as we can at the end of the webinar. If your questions contain very personal details, I just recommend contacting the presenters directly, and we will display their contact information during the question and answer period, again, at the end of the webinar. If you do have to leave early, we archive all our webinars and they can be viewed later on by visiting caregiver.org. So today I'm happy to welcome our guests, Eun Kim and Nicole Agbayani. Eun Kim is a staff attorney at HERA, Housing and Economic Rights Advocates, and they provide estate planning services and probate assistance by way of individual legal services and counseling, workshops for the public, and also trainings for attorneys. Before becoming an attorney, Eun Kim worked for 12 years in the Superior Court of San Diego, primarily in the probate division as a probate examiner. Eun is bilingual in both Korean and English. Nicole Agbayani serves as the Director of Community Affairs for San Francisco's elected assessor, Carmen Chu. In this capacity, Nicole works with communities throughout the city to share information and also programs offered by the Office of the Assessor. The Office of the Assessor is responsible for determining an assessed value on all taxable property, of course, subject to property taxation within San Francisco County. So the work of the assessor in San Francisco helps to generate over $3 billion in revenue, and this is used to help fund crucial local services like education, public safety, health, family support services, and also public works. So as Eun will be presenting first, I'd like to turn things over to her.
Thank you, Calvin. Hello, everyone. And my name is Eun Kim, and I am a staff attorney at HERA, as Calvin introduced me. And HERA is a non-for-profit legal service and advocacy organization serving the entire Californian. We are dedicated to help the most vulnerable members of our community, providing legal service to them who are experiencing economic abuses or discrimination in all aspects of household financial concerns, which include but not limited to home ownership, student loans, auto loans, other payday loans, mortgages, foreclosure, medical debts, and so on. So to help Californians preserve their homes, we launched a estate planning program a few years ago, and that is my practice area. So thank you for joining today. And let's go over what we can discuss today. I believe, next slide, please. I believe some of you are familiar with estate planning already, and while others are pretty new to this. My disclaimer of today is that I'm not here to give you any in-depth research report or to supply you with a PhD degree level of information. And if that's what you were expecting, my apology in advance. As you see the title, we will cover very basic information. And for that purpose, I would assume that all of the audience are new to this subject. Please pardon my assumption in advance. I would say this session is considered successful if you become more familiar with what estate planning is, and do I feel like I need one? And if I have one, should I tell my children in advance? Or should I keep it as a secret? Or once I made the document, should I submit the document somewhere at the court or at the county recorder's office or to someone else? Or, okay, I made up my mind to move forward for making estate planning document, and then what should I do? If you have a chance, today's presentation as an opportunity to move one step forward, and I think that achieves our goal today. So to move forward, there are a couple of common feedback that I get from most of my clients or the participants at this type of presentation when I ask them if they are interested in estate planning. Of course, the first one is they are, especially the elderly clients, telling me, honey, I don't care because I won't have any control over anything as I'll be gone by the time. Yeah, okay, I get it. And let's think if that's really true. And my favorite one is they said, my kids are completely fine. They are wonderful and they never had a fight, or they are just getting along too well. So I have nothing to worry about. So no comment on that feedback. Next slide, please. So when we say estate planning, we often believe it is all about money, and it's all for the wealth. But I think that's because the word of estate somehow leads us to believe it's all about money, which I used to believe that so too before my attorney time or probate time. Due to such misbelief, we often fail to notice that estate planning is also for my own sake during my lifetime. As many of you are providing care for your family, relative, friend, and important person to you, you might have faced some legal challenges because your voice is not honored, or you're not authorized to do anything for the person who's receiving your care. That's very discouraging, and you feel like your goodwill and good intent has been ignored and even mistreated. So if you look at the left side, it's during my lifetime. While you are completely fine and competent, you can make something in writing designating someone to manage your assets and your personal healthcare and personal affairs. That person can make such decision on behalf of you in the way that you directed, not in the way the person's complete discretion. Also, if something happened to you during your lifetime, you are still living, but you and your spouse or the other parent of your child lost your capacity, you wish that you had named someone to be able to provide the care for your minor children. And of course, right side is our typical concept for estate planning. So when you pass away, after your passing, someone can handle your estate in the proper way. And they can do all the legwork to deliver your asset to the right person as you wish. So estate planning covers both after your passing and during your lifetime. So we are kind of making pre-arrangement for unknown future. So let's look at what type of document that we need to get familiarized to achieve that goal. So if you look at the next page, you can see the chart. So the middle line is the date of your passing. And if you look at the right side, you see the trust and will. As you see that will, many of us know what will is. And will is only valid and effective when you actually pass away. During your lifetime, it doesn't have any power, it doesn't do anything. If you look at the left side, durable power of attorney for finances, and sometimes you hear general power of attorney or power of attorney for property. It's all used the same, interchangeably used. And also healthcare directive, of course, those are type of document you can name someone to act on behalf of you during your lifetime, and you get to decide when the agent's power will be commenced. And if you look at the second document, trust, interestingly, trust can be effective during your lifetime, and it can survive your passing, but still be useful after your passing. So probably you are familiar with all those type of documents, but I want to make sure that this chart is remembered. And left side is a document's name that will be useful during someone's lifetime, and right side is the document's name when will be valid and effective when someone passes away. So for trust, left side is we call revocable, because the trustor who made the trust document can change during the person's lifetime. But once that person passes away, trust cannot be changed. And then it's just the trustee's job will be just implementing the wishes and direction as listed. So let's go over the right document first. And to get in there, we need to think about, okay, so I've been curious, what will happen when someone passes away in California? So if we look at the next slide, that's indicate what will happen to my property when I die. Many of us have been wondering what will happen. So next slide, please. So the California law says, I want you to pay attention to the number in bold. So out of the paragraph, it says, if the decedent estate, the total estimate value is more than $166,250, it requires go to probate court proceeding. That's what it says. And next slide, please. So I want you to remember the number $166,250. It's a mouthful, so sometimes I will refer it to 166250. So what's a probate? When you are trying to get divorced, you need to go to family court. You should not go to criminal court even if you want to. So when you get a traffic ticket, you will go to traffic court. So when someone passes away, to wrap up that person's estate, financial matter, personal matter, you need to go to probate court. So probate court is the name of the court. And the probate court judge will decide if this decedent had a valid will, and if so, the court will make this final decision where the items and assets will go at the end of the day. So if you look at the next page, it just restates, if there is a will, court will validate the will. And court approves the final distribution depending on the will. If there is a will, assets will go to the person's name in the decedent will. If there is no will, that's okay, because a whole set of California intestate succession law, which indicate who gets what, which heirs at law are entitled to receive this decedent asset. So surprisingly, some of you might have thought, well, I have a will, so I am well covered. My estate will not go to probate proceeding when I pass away, which is not really true. Having will is a great instruction. So if you have a specific person that you want to name to receive your asset, that's great. Otherwise, it will go to the person who are entitled to your asset based on the California law. But having will is not sufficient to avoid any probate proceeding. So I have a quiz for you in the next page. And while we are turning to the next page, I want you to remember the 166250 number. So my best friend, Ruben, had purchased a home in 2010. When he purchased, the house was valued as $300,000. And unfortunately, he passed away 8 years later. And when he passed away, the fair market value was $400,000. And just like you and I, he wasn't able to pay off all the mortgages. So when he passed away, there was a pending mortgage. Unpaid balance was $260,000. That makes his net value $140,000. He had a valid will. He didn't have any other asset. So this home is the only asset in his estate. So considering the threshold amount was $166,250, is his estate subject to probate? I almost said yes, because his estate net value is lower than the threshold amount. Let's look at what the law says in the next slide. And the California law says, Probate Code 130-100, it says, if the gross value, so law focused on the market value only, without deduction of liens, encumbrance, unpaid balance, liability, how much you owe to other creditors, it's all not considered. It only considered how much was the market value of this property as of the date of the decedent death. So real property, car, bank account, any other asset, combining all together, go back to the date of decedent passing and calculate all the market value only, not the net value, not the actual equity. So market value means how much you could have sold a house, how much you could have sold your car, how much did you have in your bank account. Combining all together, if it's more than $166,250, probate is required whether there is a will or not. So let's go back to what Ruben said in the next slide, what Ruben's estate was. So same quiz. Purchased a home at $300,000. When he passed away, the house value was $400,000. Pending mortgage, $260,000. Net value was $140,000. So now we need to look at fair market value as of his date of death, not the actual value, because law says we don't consider any pending liability. We will consider the gross fair market value as of date of death, which is here is $400,000. So question again, is Ruben's estate subject to probate? I must say yes, because we will look at the fair market value, which is $400,000. Obviously, it exceeds the $166,250 threshold value. So let's go to the next slide. And this is really kind of daunting information. And we worked really hard to paying the mortgages with the hope that I can leave my house to my children or my loved ones. And your family barely make both ends meet. And if you are living in California, especially in Bay Area, no matter how shabby your house is right now, we can guarantee when you pass away, the house value is way more than that 166,250 number, right? So it will be great if we can avoid some court probate proceeding. I will go over why it's better to avoid a probate court proceeding in a little bit later. But Those are exceptions commonly used to avoid the probate proceeding. So first, left top is property held in the decedent revocable trust. It is if any asset is titled in your living trust, revocable trust, it is not counted when you calculate the threshold amount. So there is a difference. If A.Young Kim own a home in A.Young Kim's name, A.Young Kim is a single woman, I own a property in San Francisco. That is calculated when I pass away to determine whether it needs to go to probate. However, if I set up a living trust document and I had titled my house to my living trust, that house value is not added to that calculation of threshold value. Same thing. Down there is a real property specified in transfer and death deed, which is a new form to California, but it's much simpler and cheaper to make. You deed your home to your named beneficiary, but it doesn't do anything until you pass away. So you can sign the deed, notarize, and record the document at the county recorder's office where your property is located, which has to be recorded in 60 days. And it will just sit there, but when you pass away, the named beneficiary can record the additional document to take over the title properly. And also, if you have the bank account, you make sure that you name the beneficiary, unless you want to change the title to your individual, to your revocable trust. So no matter how much you have in your bank account, I encourage you, every one of you, to contact your bank or go on the website to double check if you had named any primary beneficiary or contingent beneficiary as well. That makes your beneficiary's life a lot easier, because when you pass away, all they need to do is go to the bank and present their ID so that they can match up the named beneficiary is a person who's seeking the money, the remaining funds, and they need to provide a death certificate with it. So if the asset has named beneficiary, it doesn't have to go to probate. And also, if you own a house or some other asset with someone else as a joint tenancy, which carries the feature of the survivor's right. So when multiple owner owns a property together, so two people own the house together as joint tenancy, when owner number one passes away, owner number two will take over the 100% interest. And again, if you have any totem trust account, pay on death account, and make sure you name the beneficiaries while you're doing fine, as because it will make your beneficiary's life a lot easier. And another reminder is, oftentimes I get a client who was married, but the other spouse passes away. And because the house was the deceased spouse name only, the surviving spouse believed that I don't have any right to do so. And also this surviving spouse was told from the lender saying that we don't want to talk to you because your name is not on the loan and your name is not in the property title. But in California, any asset acquired during the marriage is considered the community property regardless of what the deed says. So if you are going through such challenges, I want to make sure that you speak to a lawyer to resolve that issue. So as you can see, those are common ways, common arrangement to avoid the probate in advance. And it's not really difficult, but the consequence of having those arrangements makes a huge difference than not having it. So let's go over what revocable trust is when we say a trust. Maybe we can go to next page and see. Revocable trust is a series of instructions. Basically, you will see so many pages of document, and many of them are really hard to understand. But the gist of document is you give a direction, you make your own Bible. So there is a series of instructions that you are asking the successor trustee, who will be the person who will be managing your asset, and that person, what they can do, what they cannot do. And also, if you are not the person who is actually the managing, it specifies what you, as the person who initially made the trust, can do or cannot do. And also, I want to emphasize that your trust is different from a will. As we saw at the beginning, the chart, trust can be effective and valid during your lifetime, while your will cannot be useful, cannot be effective unless you actually kick the bucket. And also, trust avoid probate, and trustee can do their job without court supervision. The next page, please. And what information should I put in the revocable trust? And typically, common information you will indicate who your families are and who should be the one is managing and handling this trust asset. Oftentimes, if I'm making my own living trust, I'll be the one who will be handling my asset during my lifetime, as long as I am competent to do so. But in case of if I lose my capacity, if I got injured and I'm in ICU and moved to a facility and I can communicate freely, the person whom I had a name to as a successor trustee will be able to take over the managing my trust asset. And also, of course, it indicates who should be who should be taking benefit from this trust. When during my lifetime, I'll be the one who's the beneficiary, but when I pass away, I want to leave my asset, whatever is left in my trust, to my child number 1, 2, 3 in equal share. And it's important to indicate who needs to receive my asset, but also as important, who should not receive my asset. I know it sounds mean, but some of us has this different reason why you want to name the beneficiaries. So as clear as possible instruction is always helpful. But I want to make sure that if you look at the common misconception, I noticed that some people think the living trust is somehow it's magic. It's just having the signing the document itself is just somehow magically leave my house to my children without going to probate. That's not true. Little or no post-death work is required. If that's what you believe, I want to make sure administration of a revocable trust involves many of the same tasks that are required in probate proceeding. What's the difference then? And your successor trustee can handle your asset at his or her or their pace without going probate. For going to probate, it requires every single petition, every single act needs to get supervised by the court, which takes a lot of money and time. So the main difference between living trust and will is going to probate and not going to probate. And next page, please. And we are familiar with will. Again, will is only effective when you pass away, but it has similar information with the trust. So who should be receiving my asset, who will be responsible for wrapping up my assets and other matters properly. But will still needs to go to probate proceeding, unlike a trust. And let's compare briefly what's the difference between having living trust and will. when someone passes away. We can see the chart at the next page. So if right side, let's look at the right side first. If you have a will or no will, probate is required. I've been saying the same information over and over. Going to probate means that all the information you file at the probate court becomes public record. It sounds interesting because it's all personal matter, so we don't get it why it cannot be confidential information. But in the eyes of the court, it is public record. So once it's filed, anyone, your busybody neighbor, can go to the court and request a file and they can look at it. Now a lot of files are available online, so they can even log on and pay a little fee and they can view entire file. But if you have a trust, you don't have to record, you don't have to submit your living trust to anyone else. So it keeps greater privacy. And also, let's talk about the fee. In the probate proceeding, there is a law guarantees how much the personal representative and the person's attorney can take as a fee. There is a formula based on the entire asset value. While living trust, it takes a similar administration, but there is no fee guaranteed by the law. So, of course, there will not be any free work, but at least the attorneys and trustee will charge based on the actual work they has done, regardless of the size of a estate. And also, it used to be when you are receiving Medi-Cal, your asset is subject to their reimbursement. However, it got changed a couple of years ago. The department can request the reimbursement for the expenses they paid for the patient from the asset. It used to be, but now it's changed to they can request reimbursement from the asset only subject to probate. So if I am receiving medical support, and if I have a house in Ayoung Kim's name, if they had paid $200,000, they will request, they are entitled to get reimbursement from my house when I pass away for the amount they had paid, and I'm sure plus interest. But if I have the house in my living trust, when I pass away, which is not subject to the probate because I made sure my house is owned by my trust, then the reimbursement right is not going to be implemented. So it's a great change. When you have an asset in your living trust, which is not subject to probate, thus it's not subject to estate recovery. And again, so trust can be used during your lifetime. It survives your death, and they can continue the administration while the will is only valid and effective when you pass away. So next page can indicate why the probate is so notorious. So when you go to probate court, asking them, Judge, I would like to be in charge of this decedent estate. Those are the priority what judge will based on. If none of spot A, B, C, D, E, F, G people, if no one is stepping up, judge can order public administrator in number P, step up and then take care of this asset. And also if public administrator says, I don't want to do it, and creditors can step up saying, Your Honor, and this decedent owed us $100,000 and no one of their family is stepping up. But I know that we are entitled to receive that $100,000 money that decedent owed. Let us handle this decedent estate, and at the end of the day, let us get paid as we are entitled to. And if no one is stepping up, any other person can be appointed. So pretty much anyone and everyone. And next page, please. And this is a table of consanguinity. And as I mentioned, this one indicates who just like a chart of who's your daddy and who's your mommy. And there is a law in California, the intestate succession. So, and also there are people who will find out who are the heirs at law of this decedent. So as you can see, person is a decedent. When this person passes away, first it will go to children. If there is no children, it will go to parents. If there is parents passed away, and then it will go to siblings. So there is a series of law helps the judge to make an order who needs to receive this person's asset. So in the worst scenario, or in some scenario, if you have no family member and someone will find your third cousins in number 11 at the very right bottom corner, third cousins thrice removed. Someone you never met before and someone you have no information at all, but it will end up going to that person. So if I were you, there's nothing wrong to give my asset to the third cousin thrice removed, but I'd rather support my best friend child to go to the college and get good education. So maybe something to think about. Let's go to, let's continue at the next page. And I've been telling the probate, we need to avoid the probate. And why? This is a major reason. Because in California, there are just statutory fees guarantees to the person representative who is handling this decedent asset and the person's lawyer. So it's like a double charge. And first $100,000, 4%, next $100,000, 3%. So there is a way to calculate this fee. And also additional law supports that if there is some more work, such as the sale of the house, which is very common in decedent estate, the people can charge more fee. And next page shows the example. So let's say this person had $1 million asset, combining all assets together. And it's not very uncommon in Bay Area. So right side is probate administration. And this person's gross fair market value of estate was $1 million, and there was some liability, and there was basic cost of administration, and net value, the end of the day, is left in the pot $680,000. So far, it's the same situation, whether it's a trust administration or probate administration. In probate administration, because of the statutory fees, is $23,000 can be deducted to the personal representative, and another $23,000 can be deducted to the personal representative's attorney. And also, if there was additional work, which is the sale of house, those people can charge extra fees based on their actual work. So at the end of the day, the balance for distribution is $625,000. On the contrary, because of no statutory fee guaranteed in trust administration, the successor trustee and their attorney can charge based on their actual work. So at the end of the day, they have balance for distribution. So we are talking about between 6,000, we are talking about between those discrepancy, 30 grand or 40 grand, which is big enough money to me. So with 30 or 40 grand, you could send your grandson to a college with a trust, but without trust and going to probate, you are sending the attorney's grandson to college. So I would consider putting your effort and some fees to set up this living trust. Let's go to next page, please. So this is just simple quiz for you, and I want you to just look at it later, how Pamela and Alex had the exact same asset, but at the end of the day, because Pamela made the proper measures, none of her asset will need to go to probate, while Alex's asset, $735,000, needs to go to probate. So it is important to keep this pre-arrangement by making proper estate planning. Next, please. So we've been talking about the document, the right side from the chart, what's good and what's valid, what's useful after your passing. But we have a few more minutes, so let's go over what's good for left side. Power of attorney is a written legal document that gives another person, we call them agent or attorney in fact, the right and authority to act on your behalf. And power of attorney is a great tool. You can limit the power by saying, I allow my agent to do ABC work only. Or you can say, I allow my agent to work from the January 1st, 2021 until I return from my military deportation. So next, please. And sometimes power of attorney has so many names, I got confused. But if you look at the bottom, if you don't say anything in just general power of attorney, it's effective from the signing date. And the validity stops when the principal, the person who is giving power, lose their capacity. So if you are a caregiver and if you have your the person's power of attorney, make sure and read when your power starts, when it ends. But oftentimes it says durable power of attorney. That means durable power of attorney start effective from the signing date, and it lasts the person's incapacity. So, but the end of the day of this power of attorney is everyone is same. It just ends with the principal's passing. But if I'm making power of attorney, making Nicole as my agent, I am perfectly fine. I want to make my own decision while I'm okay, but I want to get prepared. If I lose my capacity, I want to have Nicole to be able to handle my financial matters on behalf of me. Then you are using springing durable power of attorney. So you make the document today, but my agent power doesn't start until I lose my capacity or until the other time that you specify. And also the next page will show everyone is familiar with healthcare directive, and same concept that you name someone to handle your medical determination and decision. I believe the FCA website has detailed information about power of attorney. So if you haven't done so, I encourage you to go to the website and look at the information. And next, please. So I went over the basic information, and if you have any too personal questions, and maybe since there are so many audience, you can just email us or call us. We can discuss more. And we are providing a estate planning service based on your income. So fee will be sliding scale fee based on your income. So if you would like to know how much it will cost, I believe that's the most important question. So make sure you contact us and we will give you the better answer for it and better estimate. Thank you very much. And I will just let Nicole take over.
Great. Well, next slide, please. And thank you so much, Ayoung. Good morning, everyone. Once again, my name is Nicole Agbayani, Director of Community Affairs here in San Francisco County for our elected assessor, Carmen Chu. Just want to start off by thanking everyone for taking the time and your mental energy to join us today, and also thanking Family Caregivers Alliance and Housing and Economic Rights Advocates for putting this together and hosting us today. So just so you are aware, I'm briefly going to complement all of the information that Ayoung just provided by talking to you specifically about how property taxes work in terms of transfers in families. And please note that the information I'm sharing pertains specifically to the state of California. All right, next slide, please. Great, so one of the things we need to build an understanding around before speaking about transfers and families is understanding how assessed value and property taxes increase over time in California. And to do this, I'm briefly going to explain to you how our property taxes are calculated and how California Prop 13 works. Next slide, please. So first off here is the formula for how property taxes are calculated, and I'll walk you through each one of these factors. We start this formula on the far left with your assessed value of your property. So depending on what county you live in, it's the responsibility of your county assessor to determine the assessed value for all taxable property in that county. In that next box there, the tax rate. So we multiply the assessed value by the tax rate. In general, the tax rate in California is 1% for secured property taxes. It varies county by county. And so here in San Francisco, for example, our tax rate is just slightly over 1%. This current year, it's 1.1801%. And the reason why it's not flat 1%, but a little bit more is because here in our county, it increases slightly year to year, depending on our county's amount of bonded indebtedness each year. And so returning to this formula, after we multiply your assessed value by the local property tax rate, then there's additional charges that are added to the bill. So when you receive your property tax bill in the mail, it's folded in 3, and you'll notice these charges in a box below the fold that we call it. So these would be special assessments, fees, and liens. Essentially what they are voter-approved measures that are added to the bill, and they're there as a convenient means of collecting the funds. So they're actually separate from your ad valorem property taxes. I'll give you an example. Here in our county, we have 3 parcel taxes that have been approved by the voters. All of those charges go to fund our local school district, but they're separate and in addition to the property taxes that folks pay. And I want to note for everyone that it's important to know that these special assessments, fees, and liens that you find on your bill, they are not capped by California Prop 13, and so their growth over time does not work in the same way that your assessed value does. So finally, looking back at our formula here, we take all of these factors and we calculate your property tax bill. The way that it works here in our county is our Office of Treasurer Tax Collector is a separate office from the assessor. Their responsibility is to collect all of this information. They generate the bill, send it to you, and then they collect the revenue. And so before moving on from this slide, I just want to emphasize the reason why we highlight the assessed value in a different color there is because really that is the underlying variable for this whole equation of your property tax bill. So you can see as your assessed value grows each year, so your property taxes will go up as well. All right, next slide, please. So to understand how your assessed value and your property taxes grow over time, we need to talk a little bit about a law that we have here in our state called California Prop 13. So to provide you some background, Prop 13 was passed by California state voters in 1978. Under Prop 13, when there is a change in ownership, so for example, when I purchase my home, the county assessor determines what is the fair market value of my property at the time of that purchase. This value becomes what's called my base year value. And from then on, the assessed value of my property will increase by no more than 2% each year, unless a few triggering events occur. So for example, those triggering events could be I purchase a new home or I make significant construction improvements to my current home. And then as you can see from the text on this slide, the market value for your property in many of our counties here in California grows much faster than 2% each year. So this is why over time, a property's assessed value will become different from the property's market value. In most cases, by and large in our state, the assessed value would then become lower than the market value. Next slide, please. So this is a depiction of what I'm talking about between the growth in market value versus assessed value. If in this example, let's imagine that I purchased my home in 2010 for $500,000. So at that time, the county assessor here in San Francisco would set my base year assessed value at $500,000, or my home's fair market value. And then from that time, year over year, you can see the blue line, my market value, going up much faster than 2% a year. And yet the red line is my assessed value. That is going up gradually by a maximum of 2% a year. So that is what is capped by California Prop 13. So I mentioned that there's certain events that can trigger the county assessor to reset your home's value back to the market value. What we would call this is reassessment of property. So looking at the graph here, what that would look like if the property were reassessed, let's imagine in 2014, it would be if my red line, my assessed value, went back up to where my blue line is, which is the market value. And so looping back to our topic of today's webinar with estate planning, one of the aspects of estate planning that is potentially incorporating the transfer of your property to your family. And so reassessment may occur when you are having a transfer of your property. So next slide, please. And so what I want to talk to you about for the rest of my brief section here is how to avoid reassessment and save money on your property taxes when you're transferring within family. And so we're going to talk specifically about another California law, California Prop 58, which is an exclusion from reassessment. Next slide. So California Prop 58 allows property owners to avoid reassessment of their property if they are transferring that property between parents and children. Next slide. And I'll talk you through some of what the eligibility for the program looks like. So first off, we need to talk about what our state considers to be an eligible child for the purposes of this transfer. So our state would accept a biological child, a stepchild, an adopted child as long as you adopted them before the age of 18, or a son or daughter-in-law. Next, eligible transfers. So you can sell your property to your child, gift the property to your child, leave it as an inheritance, or what we've been talking about today, you can transfer that property via a trust. There's also provisions for what's considered to be an eligible property. So in California, we think about property in two buckets. First, your principal residence. So this is the home that you own and that you live in. Individuals or married couples in the state of California can only have one principal residence, but people own more than one property. And so the second bucket would be every other property that you own. So for your principal residence, there is no limit to the value that you can transfer to your child and have it be excluded from reassessment under this Prop 58. For all of your other properties, though, there is a cap to the amount that you can transfer before any dollar over that value begins to be reassessed. That cap is $1 million in assessed value. If you are married, it is $1 million per spouse. And then important to note, I'm talking about assessed value and not market value. So it's a $1 million assessed value cap that can be transferred under Prop 58 and be excluded from reassessment. And a final thing to note about Prop 58 is that this transfer can actually go both ways. So for the purposes of today, we're thinking about parents transferring their property to their children, but you can also use this provision for your children transferring your property to you as the parent. Next slide. Oh, next slide. So a little more information on how to contact the assessor's office. I believe if you click forward here, it should show you. This is an event that we have. I encourage folks to jot down this link here to pre-register. I'll quickly mention it's an event that allows folks to get information on estate planning one-on-one. So if you found this information helpful here today and you want to sit down one-on-one with an estate planning attorney, it's a free event open to the public here in San Francisco, and you can pre-register at this link. Next slide. And here is our contact information if you'd like to reach out. Happy to answer questions after this presentation, and I think we have some time for questions right now.
Perfect. Thank you so much, Nicole and Ayung, for joining us this afternoon. I imagine everyone probably understands we're all working remotely because of the current coronavirus pandemic. So thanks for joining us this afternoon, both speakers. So we do have a bunch of questions, and I'd like to get into it right away. So the first one is a listener who wanted to know how to find a reliable attorney who works with trusts.
So typically when, of course, the HERA, you can find that our information at www.heraca.org, and you can contact us for help. But if you would like to get some more information to shop around which attorney will fit your situation, you can go to the local bar association, go to referral services and ask them to give 3 or 4 probate attorney or estate planning attorneys who are focusing on their practice area. So you have to talk to them, brief information, and you will know which attorney will respond you in the way that you are anticipating. So that's all I can say. So just go to local bar association, trying to obtain a few list of the name, and make sure you demand someone who will practice estate planning.
Perfect, thank you. Got another question about, let us see. They wanted to know, are there any implications or are there any, I guess, differences if one of the homeowners or a property owner is not a U.S. citizen, say a permanent resident, in terms of either the taxation issues or the trusts and wills and things of that nature?
So I believe the non-U.S. citizen can own a property here. And if you are, if for married couple, if one spouse is the citizen and the other one is not, so there will be some tax consequence because you will have a different tax exemption amount for non-citizen. So if you have serious concern regarding if you are, if you have asset, the couple's asset is more than $600,000, you probably need to consult with a estate planning lawyer so you can design your estate planning to avoid any big estate tax hit. So there is a way to reserve your asset when surviving spouse is not a U.S. citizen. But it's kind of too complicated to discuss at this time. You're welcome to contact us and talk to other estate planning lawyer, but there is a way to avoid a big estate tax hit if you have large estate.
And then Calvin, just on the taxation side, so there's no provisions in California Prop 13 or California Prop 58 in terms of citizenship. So any property owner would be able to access those programs.
Great. I have another question about a caregiver of someone who's going through a conservatorship with her mother. She was planning on adding her name to her mother's deed, and she was wondering, would there be a cost to that, and what might be the disadvantages or what might be the things to consider about someone in her place or someone attempting to do the same thing?
So unfortunately, if a person is subject to the conservatorship, that means the court has already determined this person, the conservatee, has no longer make the financial and personal decision because of all the lack of capacity. So meaning that you cannot, even if you are the conservator of this conservatee, you cannot add your name to this property. You probably need to speak to a lawyer who does conservatorship of a state, and because there is one probate code section law allows to conservator to change or make will of this conservatee to preserve this conservatee's asset. It won't be simple deed like a competent person, but going through the conservatorship procedure, you will still have chance to preserve your parent asset. But it's it takes a while, but you will be able to get the mission accomplished. So my answer is seek legal advice through the conservatorship lawyer who can assist you to preserve your mom's asset.
Okay, thank you. I have another question. This listener wants to know, are there any taxation differences between, say, transferring a home to a child in one instance during their lifetime or in the second instance after their death, say via a trust?
I'm so glad that this question was brought up, and to simply, so if I'm a mom and if I want to leave my house to my daughter right now, because of all the property tax, all the burden, it's great because my daughter can be an owner of the house. But there will be some capital gain tax issue when my daughter decides to sell the house. Let's assume that I purchased my home for $200,000 30 years ago, and today the house value is $1 million. And then I transfer title to my daughter. And 5 years later, I died and my daughter decided to sell the house, which becomes $1.2 million. From the sale, because she got the sale proceed, she needs to be responsible for capital gain tax. Simply, the sale value was $1.2 million. Now we need to find the base value, which will be the $200,000 when I purchase the house. So my daughter will be responsible for the proceed of $1 million to pay the capital gain tax for it. But if I leave my house to my daughter through my living trust, and when she decides to sell the house, the base calculation, so sale price was $1.2 million, but if house value was $1 million when I pass away, she will be responsible for the gap, $1.2 million minus $1 million, because she inherited the house upon my passing. So she will be responsible for the capital gain of $200,000 only. That will make a huge difference. Also, adding your child's name to the deed right now can be subject to your daughter's creditor, because whether behind the scene, whether you are the homeowner and your daughter is just, you're borrowing her name on the title, it doesn't matter if your daughter becomes subject to a lawsuit, and if the other side put the judgment on your daughter's property, which is actually your house, you may end up foreclose your house and losing your place to live. So I don't know if it makes sense, but there is a tax differentiation between leaving your house to your child at the time of your passing or during your lifetime. Nicole, do you have anything to add?
Yeah, thank you. So just to add from the property tax perspective, if you're looking to take advantage of California Prop 58, the parent-child exclusion, the timing of that can be either before or after your passing. You'll still be eligible. One thing that I do want to add is that Prop 58 is not an automatic benefit. And so if this is something that you would like to transfer your property to your child via trust and have that change in ownership occur after your passing, your child is going to need to make sure that they're filling out a form. It's available on the California Board of Equalization's website. And I can share a link with Calvin to share with the group after this webinar via email. So they'll need to remember to fill out that form after your passing to make sure that they are not reassessed. So there is an action item for the child.
Okay, fantastic. I think we have time for just two more questions. I have one from a listener. It looks like they or the person they're taking care of is going to have to sell their only home and is to pay for the cost of a long-term care facility. Do they have any special tax rate for that, or is that just considered like any other transaction in terms of having to sell your primary residence, I guess, or your only residence to be able to pay for a stay in some kind of a residential care facility?
Well, I'm not a tax attorney, so I am not sure, but maybe that's something that you need to discuss with your tax expert, that if you have your CPA or the tax attorney. But I cannot imagine there is any special tax rate. But again, I'm not a tax attorney, so I should not say conclusively.
Okay, I think we have time for one more question. This is someone who owns a property currently in California, but they actually may not live in California full time when they pass away. Are there any special considerations for them? Anything they might want to keep in mind in that situation?
For the estate planning wise, it's if you make a trust and put your California property into your living trust, the law which controls the trust will be California law unless you specify it otherwise in your trust document. So that's commonly happen, or vice versa. Someone who lives in California has other rental property in other states. If they add that property into California trust, that the outside of real property is still controlled by this California trust. Same thing, once you make a living trust and put your house into your living trust, the management or administration of the trust asset will be governed by your California trust document. So it doesn't really matter for estate planning purposes whether you will reside in California or not.
And then in terms of property taxes and taking advantage of that California Prop 58, just want to recall back to the detail around principal residence versus every other property that you own. So if that is not your principal residence, the home that you own and you live in here in California, then transferring to your child would be subject to a $1 million cap in assessed value. And you would be reassessed for anything over that $1 million cap.
Okay. Thank you both so much. I think that's all the time we have now for today. I'd like to thank everyone for participating in today's webinar. Again, presented by Ayun Kim and Nicole Agbayani. These FCR webinars are a continuing series, and you can find more webinars on our website. Of course, we are looking to expand other offerings in terms of online classes and courses, since it seems likely we might be shelter in place for a little while longer. I'd like to thank again Ayun and Nicole for joining us today.
Thank you.
Thank you.
So the webinar is now concluded. We hope to see you all for the next one. Please, everybody, stay safe and have a fantastic afternoon.